definitions, I imagine you got a dictionary and shit. This is all compilants. This is all like common words I'm using.
I would have actually, if it doesn't make legal sense, then I'd have been like, well, then maybe you need to get an attorney. Well, I am an attorney. Well, you should understand it. That means you're not a competent attorney.
Well, this is when he ordered him. He ordered him to be there on the 6th of October, which is like a couple of days from now. And he already sent him the judge. As per my notice, this is what I charge. Excuse me. Went on the website tonight, and we cannot find his court case. So we believe it's like dropped. However, and the notice is if you send us a link to go to court, then this contract is binding. I'm going to send you all this because honestly, I think you're going to get a kick out of it.
Yeah, yesterday I spent more time working on a document I'm working on dealing with the law of agency and who owns the property, because I'm going to send them this as my acceptance of that office and say, hey, according to the congressional record of March 9th, 1933, you mortgaged everything. That makes me a property manager, and I don't work for free.
You can.
Well, you
That's the
can
beauty of
work
it.
for free. I mean, but I wouldn't.
And that's my whole.
If they mortgaged everything March 9th, 1933, and it's their obligation, then we should start sending them their obligations so they can balance the books. And I tell you what, if we want to get rid of the national debt, that's really what we should be doing. Stop pointing the finger at government and get enough people start saying, hey, government, take care of your obligations. Inflation will go down, the budget will go, the national debt will go down.
Well, national debt ain't going to go down unless we discharge our debt.
Well, it's not our debt. It's theirs. It's their obligation. They
Right,
can't
but
balance the books
right,
if
but
we're
they
not
can't.
sending them what they're
Right,
named.
but they can't discharge it, or I should say, set it off. They can't take that shit off the books. We as human beings need to take this shit off the books.
Actually, yes, they can. It's their account. It's their books. They can. What do you think it says in the Constitution? It even uses the word set off in the Constitution. So they have the power. The problem is they can't if we're not sending them what they need.
That's exactly what I'm saying. Is we the people, or we, if we don't send them the right information, they can't do what they were hired to do.
That's right.
And again, we don't know how to do it. This shit wasn't, like right now, I believe that the words coming out of my mouth, you understand because you went through some type of schooling to understand, the ABCs and one, two, threes, and like you and I can communicate with each other and at least produce a thought upon which you can ponder and then retort with. That's taught in school. But what you're talking about and what this W-4 process or 1099 process or tax process, man, that is not taught at school.
No, it's not.
So we have to learn this, for lack of a better vernacular, secondhand.
We have to learn it
That's
through the fire sometimes.
we do, but that's why I don't know. 90% of the population in all of these different groups is you do it, you show me, and you prove to me, then I'll move forward with you.
And those are the people that I say will never be free because they'll never do the prerequisite study to learn how to stand on their own 2 feet. That's why they'll go into court, won't be able to defend it. And the government loves those kind of people because then they come out and say, oh, it's all fake. It's all this. It's all that.
Well, that's really actually kind of funny because this is probably about 2.5 years ago. I had a man at court sit there and say, according to Supreme Court, these are his words. The Supreme Court ruled fucking blah 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 blah. Therefore, I should not be. And in conclusion, the Supreme Court ruled blah 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 blah. Dude was like carted away, like the word carted away would be literally a gurney, but like an upright gurney, like I don't know, like a moving furniture. What the hell's that thing called? An upright gurney.
Hmm. I don't know, but I get your point.
And then I went in behind him, and I said, like unto the Supreme Court opinion, blah 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 blah, and like unto the Supreme Court opinion, because the Supreme Court doesn't make rulings; they make opinions. And if I were to say that a particular Supreme Court ruling or a statute or code that was, changed or altered or, set aside or, vacated or whatnot, I know damn well I can't say according to
I've
Jones,
actually seen both.
like Jones versus Smith, and I give the actual court case, I give this and this and this, and act as if it is my own. That's what this other guy did. I was like, well, no, I did not sign anything. That's not my case. I enjoy the ruling or, the decision-making process on that, but I can't claim that that is mine. Therefore, I'm going to say, like unto this case, meaning I'm separating it from me because I can't say, well, according to case number blah, 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 blah. Man, I'm not a lawyer, and they understand that. I don't have a degree to interpret shit. But what I can say is, like unto thou shalt not, boom. Like unto the Ten Commandments, like unto Matthew, like unto. That's what fucking saved my ass. Because they absorbed everything that I had to say. And this was like 2.5 years ago. So a lot of people want to, like, put, case law into their deposition or deposition or however they want to do it. They had better, put in there like unto this.
Or compare to, or for example.
Exactly. Because if you don't do that, if you just put in the case, then they believe that you are a member of the bar or you're taking on the responsibility of understanding this and that. And then when you have been found that you are not that, well, you're just a heretic. You're just a monster. You're just, you know what I'm saying? However, if I were to say, Pastor the Way won a case between him and Comcast, and I have Comcast, and they did the same thing to me. However, that is Pastor the Way's case. However, like unto Pastor of the Way's case, I too was blah, 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 blah. Then they can hear it. Then you don't need a lawyer. Then you don't need an attorney. And I think that also goes with trust. I think that goes with a lot of different things. By literally saying, like unto, I yield. Because honestly, at the end of the day, we can look at a court case summary. We can look at a court case summary. But honestly, at the end of the day, I did not author those words. And if I did not author those words, then I'm not held liable for those words. Therefore, you can't even use these words that I'm saying in this court case. It should be admissible. It can't be.
That's why I always say, quote the principle, compare to the case. Because the judges will tell you the principle in the cases. So just adopt the principle, but compare to, or as you say, like unto, principles of law. Nobody has a right to control the principles. They can only control the methods.
Right. But also at the same time, you cannot have a fictitious plaintiff. Black's Law Dictionary, 4, 5, 6, and 7th edition, upon it all. You cannot have a fictitious plaintiff. And the definition is very clear. If the plaintiff does not know its own name or repeat it at court, then there is no plaintiff. However, if I go to court and say, I would like to have everything on the record, and they're like, oh, well, we're recording you. We got to snark. Man, that's not on the record. I need to take an oath or affirmation upon which I'm saying on the record. And I require the plaintiff to do the same thing. Well, the plaintiff can't do it because it's the people or the state of Nebraska or Texas, or, you know what I'm saying? It doesn't exist.
Yep.
It's fictitious. But I'm telling you this right now. It is contempt of court based on Black's Law Dictionary to bring forward a fictitious entity at court that cannot say its own name. And they just move forward anyway. They will bind you or gag you or put you in a chair, and they're like, "Oh, I think he's spinning." You know what I mean? So we got to figure out a way to take the information that obviously that you have, but I'm also thinking, and this is just me, man. This thing needs to open up to like court stuff or procedural. Because you bring up that, yeah, you know,
I don't look at a lot of those arguments. I mean, I stick to what can be proven. We know it's a constructive trust. Well, it means if it's a trust, it's a legal fiction. Legal fictions have to have agents to operate.
Right, but how do you get the agent of the people or the state of California or the state of Nebraska or whatnot to admit at open court that they are illegitimate? They won't do it.
They're not illegitimate.
They can't. They can't represent a fictitious entity. They can't represent a fictitious plaintiff.
The people of the state of whatever is not an illegitimate. It's not a legal fiction. It was created by a constitution. It's a legitimate process. One of the things that you got to look at is the Trust Indenture Act of 1939. The obligor has to produce the trustee. Who's the obligor?
And I guess
Pastor, can I ask you a quick question? I'm sorry, Steve. It's kind of important, and you guys will go on forever. I'm responding. Yeah, you got to give room for other people who are in need. No, I'm just kidding. Okay, yeah, I'm responding to American Express. And the executor. I just realized the Express executor assistant just received my last letter to them, and they gave me a time to call with an extension and asked if there was a better time. And they're researching my claim as it relates to my inquiry. So I had sent them a claim and an inquiry about my position with them. And so I had sent out another instrument prior to seeing this. I don't want to say too much to them. I'm just saying, thank you for your response. Our office just got this and it was not seen. Another mailing was sent out prior to seeing this. This is a good time for me to call and will as soon as possible. If not today, at this time, I will Wednesday at this time. Look forward to speaking. And then I'm wondering, should I sign my name or not? Like, should I say, like, look forward to speaking and then put my name and then comma, my first name, comma, beneficiary, or just leave out my name altogether because I'm not sure what position. I mean, I know what position I'm responding from sometimes, but not all the time.
Did they send it to you in writing, and are you responding back in writing?
Yeah, it's in an email.
Then they didn't sign the email, so why would you? How can you sign an email unless you do an electronic
signature? It just says sincerely D. Bailey, and then it has his position, American Express Executive Assistant.
Then yeah, you can do that. You can sign your official title.
That's the problem. I'm not sure what because I'm playing a few different titles right now. I'm not sure what my title is in signing, or Well,
that's.
Oh, I know what you're gonna say, Mr. Ego. I get it. That's the problem. Well, this is how we learn. I can read code, uniform commercial code all day, but I don't learn that way. So, it doesn't. This is easier for me to learn this way and more productive. So I'm thinking, because I'm also the representative for me, I'm writing this, the beneficiary. So I would do my name, comma, beneficiary. But because I'm also acting as the executor, right?
My argument is you're not. Where's your evidence that you're the beneficiary?
I formed a trust with this company,
Okay.
and it's in
Formed a
their
trust with
indenture.
American Express.
Yeah, and their indenture has me as the I'm listed in their trust indenture as, accounts receivable. So I'm just,
Well, if they're listed, if you're listed as accounts
well, not
receivable,
me, but my account is.
if you're listed as accounts receivable, that is not a beneficiary.
Okay, listen, they're going to give me what I want, so I just need to know how to sign this. It is, because you don't understand. If you read consumer law, I'm the beneficial interest owner. So they are supposed to assign the credit back to the account, and I'm making a proposition deal with them. Instead of giving me a check, I just want them to put it back on account. Plus, I've made good faith efforts to them, so they're willing to work with me.
You can be a beneficial owner and not be a beneficiary.
Yeah, I've done that too. Beneficial interest owner.
Is a trustee a beneficial owner?
No, but since I'm writing the letter, I was just thinking, like, should I do representative or beneficial interest owner? Maybe just not just sign, me as the beneficiary with the, name, no title after,
Do you have a legal dictionary?
I have a couple.
Have you looked up these definitions in the legal dictionaries?
Yeah, of course. But it's just the context is always like confusing a bit when the lines are blurry because you haven't concreted the contract.
I can't tell you how to sign because I don't know enough about the situation.
No, I hear you. Okay, that's cool. If it's not an easy answer, don't worry about it. I'm just going to not sign it all and, call it a day because it's just an email. You know what I mean? That way.
People do like making claims that I am this, I am that, and they want to sign that way. And
well, all I was doing was claiming the interest. So, and they're respecting that, and they have to respect that under consumer rights.
I understand. Okay. But the consumer laws, if there is a law in place that says you are the beneficiary, then you can sign that way.
Yeah, it does say that because the consumer is the beneficiary in this situation.
Then you've answered your own question.
Yeah. Okay. I just wanted to check. I just like to check with people because, I'm still learning. Thank you, Stephen. I'm done.
Hey, I have a question for you.
Yes.
My question is, do you believe that there is a particular way that you sign or you autograph or you present your okay on any piece of paper or any electronic device or whatnot? My question is, do you believe that there is a wrong way or a right way to do it? Meaning you're going to do it, but you don't know enough. Like it's wrong. Like if I sign it, that means I give away, my eggs, or I give away a portion of my brain, or you see what I'm saying? I guess my question is, do you believe if you were to put your mark on something that it would have a detriment to you? That is my question.
Only in a court of law, if they were examining a trust and you had gotten into trouble due to huge amount of tax evasion or something, or maybe something else, and you had a whole thing going on where, you know, you were also having an LLC and you're, you know, had a trust, and it got pulled into a court order. Then they examined the trust, and you weren't, you know, qualifying your signature under one position, and that was in question. You know, that might make a difference. But I think practice and applying brings, you know, actual integration into one's understanding.
I don't just believe it, I know it. If you don't know the capacity you are signing in,
Hello? Everybody went all dark. Did somebody cut me off? I can't hear anything.
Nope, it's just quiet. My coffee's good this morning, though.
Oh, okay, cool.
You know, there's a principle that states, you know, you must know all the conditions that you're getting yourself into. And an example of that is,
okay.
you know,
Sorry about that. I got a phone call. Now, what I was saying a second ago is I know it. I've read the court cases. And the ones that come to mind is dealing with the trustee. There's court cases where the quote unquote trustee was acting as trustee, but he wasn't signing as trustee. Okay. So signing in your proper office or capacity does make a difference, as into whether or not there is a liability.
Right, but the person signing for something has to disclose the principal. Meaning, let's say I'm the agent or the authorized agent for the name Stephen Raymond Smith. I
Yes.
need to present the principal to the people that I'm talking to or communicating or, you know, creating something with.
The principal is in the signature.
Well,
Stephen, comma, authorized representative, or Stephen, comma, registered agent for. That's where it's at. That goes into the signatures on what it talks about in the signatures in the UCC. It also goes on different codes on the liability based on signature. Who is the liable party? It always
Right.
goes to the principal. So
right, and right,
when
but the principal, whether it be Pastor of the Way LLC or Pastor of the Way, you know, meaning if I were to sign for you, or I should say, let's just say I was going to sign for
let's use that.
Yeah.
If I had a power of attorney established,
Okay.
and then you signed it, Stephen, comma, POA. Okay, they might need to see the POA to see if it's a valid POA. It doesn't negate the signature because you didn't set out a principle in the document. You were signing under your official title. It's no different than the judge. When the judge issues an order, what does he have to do? Sign it in his official capacity. The Honorable Judge whatever, or Judge whatever. He's signing it in his office, so the principal is in the signature. So
all right.
It's just like the whole thing of arguing against a ticket. Well, they did it under duress. Well, did you sign UD or under duress after your name? Because when the court examines the record or the documents, did you sign it, comma, under duress? There's nothing in the record. So it is presumed that it was consensual. It doesn't say that you lay out the principle in the document. The principle is in the signature.
Well, actually, the principal, meaning Stephen Raymond Smith, that is the principal. That
No, I'm
is
not
the
talking about the principle as in the party for the liability, as in the
no,
I'm
no.
talking about the legal principle. So maybe we're talking about two different things.
Right. Well, I'm talking about the authorized agent has to disclose or present the principal, i.e., I have 4 sheriffs around my shit, and they're like, what is your name? And I said, do you want the name that my mom calls me before sundown, or are you looking for a legal name? We're looking for your legal name. Okay, want to contract business? Yes. Okay, great. That would be Stephen Raymond Smith. Here is my DBA. Here is my fictitious business name. Here is this and that. And I'm disclosing to you, as the authorized agent of the name Stephen Raymond Smith, as per this paperwork, signed authorized agent. Here you go.
Yeah,
Meaning,
no, that's
right,
yeah,
right,
that's different. I was
right,
thinking of the legal
right,
principle.
right. And what
So
I'm saying is, right. What I'm saying is, you have to disclose the principal. What's the principal? The principal would be the name upon which you are going to be doing all of your bullshit with. I'm disclosing that. Therefore,
yeah, that's
right,
different than a legal
right,
principle. I had a different thought process. That part you're
right,
right.
and right. But here's the skinny. Once I disclose the principal, which would be Stephen Raymond Smith, a fictitious business, I'm the authorized agent of that. As soon as I disclose to 1, 2, 3, 4, 5 sheriffs or a court or whatever that I am disclosing the principal. The principal is the name on the docket. The principal's the
Yeah,
name on the contract.
the liable party. Yes.
Right. Therefore, I personally am no longer a surety of the bond. I'm no longer liable because I've already disclosed it.
Yes. Now that I agree with. But like I
Right.
said, my thought process was slightly different. My thought process was dealing with the legal principle. Which office are you filling? Because we were talking about when she said the beneficiary. That is the signature that has a legal principle attached to it. Okay. No, but disclosing who the liable party is, yes, that's the same thing with an LLC. The LLC is the liable party. You may be the CEO of the LLC, and you just sign your name, Stephen, comma, and then the name of the LLC, okay, or CEO for the LLC, okay. That way, you don't hold the liability unless you violate the laws of the LLC or the indenture, supposedly, or however you want to word it. Because most people they will get an LLC written up and it'll lay out the rules the LLC is to follow. Okay, so, but as long as you're within your fiduciary duty when you sign it as that official title. And that discloses to the parties where your rights lie.
Right. So, question would be, and that's why I asked, like, well, like her question is like, well, how do I sign it that I have no liability. That's not what she said, but in a way, I think that's what her question was. Meaning, if
Yeah,
she
that's what
signs
it
it,
was.
Fiona, comma, Sarah, uh, you know,
If the
Beth,
if
and
the
then she's like, well, if I sign it, Beth, Sarah, Fiona, you know what I mean?
mhm,
Like,
yeah,
I think
if
her concern is if I
if
sign it
yeah,
a
if she's
particular way,
yeah, yeah,
or if I sign it, meaning if I put paper, pen with ink on something, is there a penalty, or is there a way that I could be harmed or damaged?
it
Because
could
honestly,
be.
you know what I mean?
Anything you say can and will be used against you in a court of law. That's just not verbal. That's also written. So if you don't sign it in your right capacity, yeah, they could use it against you.
Right,
That's
but
why I
also,
said if the consumer laws physically state you are the beneficiary, then hey, and yeah, you can sign it as the beneficiary for blah blah blah. Okay, but if the consumer laws don't say you're the beneficiary, then where's your evidence that you are? Okay, sign it in your right capacity according to what the laws are pertaining to that instrument.
right, but at the same time, it used to be, uniform, you know, UCC 207. And there's
Well, they changed it
UCC,
to 308, but
yeah, exactly.
yeah,
So,
and
I mean,
I
I
don't
guess
have a problem using those principles. I don't advise using the code, but what is the UCC? It's nothing but principles. Okay, the principles, whether they put them in a UCC or not, the principles still exist, and it even gets in the UCC. It even talks about your signature, how to sign, who are you signing for, etc., etc. Okay.
well, how about this? I get it. I understand it. And I understand that, statutes, codes, ordinance, and responsibilities and obligations and whatnot change by the whim of authors that we may or may not know.
Yeah, but the principles never change.
I know the law doesn't change. Principles, I think they do.
No, the principles of law never change.
Well,
In
there was,
contract law, you have to, the principle in law, one of the principles is called good faith and fair dealing. Does that principle exist because they put it in writing, or does it exist by nature? It exists by nature. You are to act in good faith and give fair dealing. Okay? That's a principle of law that's existed before this country existed. It's called doing
okay,
good business.
okay, okay. How about this? I 100% agree with that. However, I could walk into any courtroom anywhere here in the United States, and that law that you are talking about don't fucking exist.
Yeah, it does.
Because if no, it doesn't.
Yeah, it does. I can prove it. I can sit here and prove to you in the Restatements of the Law and Contracts, second edition, 74 times they mention criminal cases dealing with plea agreements. And in one of those times, the plea agreement got overturned because why? The DA, it was proven, did not act in good faith and fair dealing and
How can
honor the contract. Okay. But do they
how
quote
how
the
how, how can you
law?
right? But how can you say that though?
How can I say it? Because it's in their writings.
Well, how about this? Let me just run this scenario real quick. a guy gets into his car and he's going from point A to point B, and he is interfered with his right to go from point A to point B because he sees lights and sirens and whatnot.
Did you ever get? Does a gentleman
Hold
always
on.
gives notice?
Hold
Did
on.
you ever give them
Hold on.
notice?
Pastor the way, I've tried not to interrupt you.
Okay.
Okay, here we go. Going from point A to point B. Lights, sirens. It's an emergency vehicle. Did you see me cause any harm, damage, this and that? Well, no. So you're interfering with my right to go from point A to point B. You put your emergency lights on in your emergency vehicle. So what is the emergency? Oh, there's no emergency. I just needed to talk to you about if you've gone down to the DMV or if you've, checked this light bulb or whatever. Bottom line is, this man's going to go ahead and, let's just say, write you a ticket for whatever. Okay? And he says, you're not admitting guilt. You're not this. You're not that. I need you to sign this instrument, this ticket, this citation, whatever. And if you don't do it, I'm going to cause you harm and damage. Under force or coercion, you sign the ticket. 2 months later, now you have court. And this is the bulk of my scenario here. 2 months later, there's what's called a drafted informational complaint.
Yeah.
And this complaint is certified by John Jones. And this complaint starts off with, on or about October 10th, 2021, blah, 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 willfully and wantonly violated or interfered with whatever vehicle code, section code, this, that, blah, 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 blah. And it's a complete dossier. It's a full-blown complaint written by Tom Jones.
I get the picture.
No, hold on. It's written by Tom Jones.
Who is Tom Jones?
Tom Jones is the prosecutor or the man moving forward with a complaint or a claim. And I guess what I'm trying to say is this. Tom Jones was not there that night. Tom Jones does not
get
know
all that.
Right. So I guess what I'm just trying to say is Tom Jones is writing a complaint, acting as if it is a claim, claiming damages to harm or whatever he's doing. But what I'm saying is Tom Jones was not there. He is
Was this outside of your jurisdiction where you domicile? Or was this just in the county you reside in or domicile in?
Domicile is a permanent home of residence, like where you lay your head.
Yeah, where you live, was it inside that area, inside that county? Or was it when you was traveling, saying you went on vacation in another state?
I don't understand. Well, how about this? Whether it happened here at California or in Texas or Nebraska.
I'm asking for a reason. I need context.
Well, I guess the context would be an officer of the court believed something.
No, you're missing my point. Gosh, can you just answer the question?
Okay. You're right. I'm wrong. You're strong now for having been corrected. What is your question, sir?
Was this within your normal everyday life jurisdiction in the county you live in? Or was this in another jurisdiction?
Yes. Yes. The question number one.
Okay, it was. When you decided to exercise said right, did you at any time give them notice that you were going to exercise that right? It doesn't really matter if it's outside the jurisdiction or not. A gentleman always gives notice. See, they don't know who you are. Then they pull you over. Why do you think they want you to identify? They're trying to see who you are. So what do you do ahead of time to avoid all of this? You say, look, as such and such, I will be conducting my business this way, exercising my right to travel. And if you interfere with my said right, here is my cost. Okay. We run around sitting there thinking, well, I want to get private plates. I want to do this, but we never give them notice. And then we get mad when they do their job. I mean, if you are going
His
into
name's
a
okay.
jurisdiction, do you not give the king notice? I am coming to your jurisdiction to visit with you. Okay, go back to the medieval times when one kingdom was visiting another kingdom. Did they not send notice ahead of time?
Yes,
Yes. That
they
way
did.
they knew who was coming. If they didn't give notice, you might be an invader.
Correctamundo.
That's what I'm saying. You never gave them notice, did you?
Oh no, Tom Bergman, head of CHP. He's been the head of CHP or whatnot for the past 7 years and shit. I sent him a correspondence. I sent a correspondence to Placer County
That's after the
sheriff.
ticket, though, right?
Oh no, this is before.
Okay.
This ain't my fucking first rodeo with these fucking yahoos.
Okay. Then
They've taken motorcycles, they've taken my boats, they've taken my fucking cars, and it's
then
like
you need to file a counterclaim against them.
How about this?
There's a
Here in the state,
contract in place.
right?
You gave
Here in
them
the,
notice. Silence is acquiescence.
I understand that. I understand that. And like most common people would be like, well, good, right? Or I should say, right, wrong, that's right. And we move forward. These people don't work that way. They
I
don't
don't
work
see no
that
problem
way.
with it. They will work that way if you give the proper notice to the proper people. My dad walked into the Department of Motor Vehicles, handed in his plates and his registration, and said, hey, I see no more benefit in this contract, and I'm returning it to you.
Right. And
Has
he
he
had
had
to,
any
right.
problems?
Right,
Not in
and he
6
had right,
years.
and your dad had to sign something. He had to give them something. He can't just physically walk in there and talk to Joe Blow, be like, blah 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 blah, and then leave.
Oh,
And like,
yeah, let you talk to my dad sometime.
he had to
My
give
dad's
them a
been
piece of
running
paper.
with an exempt plate for 6 years. Has he been ticketed for it? No. Is that going to be the norm? No. But he walked in the DMV and said, I see no more benefit in this contract. And the ma'am said, he gave it to the lady at the front desk, and she looked at it and said, okay, sir, thank you. And he just handed it to her and he walked out.
Were you there?
I trust my dad's word.
I'm just saying, he had to have written something
Well, how
down.
about this? How about you call me sometime and I'll put you on the phone with my father?
I guess what I'm saying is I can't talk to a California Highway Patrol officer and hand him my plates and hand him,
He's the
and be like,
wrong party.
I'm just trying to say, I have already written to the California Highway Patrol. I have already written to that. That was this is like I don't know, like 3 weeks ago, when I was talking about your dad. I was like,
Now,
I
the state
believe that
police are governed by which branch of government?
judicial.
No, executive.
Oh, I'm sorry, executive.
Not only that, they're also
But well,
governed by the Secretary of State, who manages all corporations. You're not notifying the right people. And sometimes it requires multiple notices to the right people.
I concur with that.
And then once you got the ticket, one, you already know it's not against you, the man, it's against the trust. Who owns the trust? The state
The birth,
does, right?
yeah, well, the state of California or the birth
Why did
certificate,
you
the
not?
birth certificate agency or the Social Security
Yes, so
agency.
why did you not take the instrument and say, hey, as the agent for the trust, your person has an issue that needs to be settled? And send it to the
Because
governor or to the treasury and say, hey, please settle this matter for your person. That's one of the documents I've been working on. I've about got it finished.
yeah, because honestly, where I'm at, I don't know if it's just this county. I don't know.
It's not. It's people say, well, this county's more corrupt than everywhere else. No, they're not. It's the
I
same
just
everywhere.
know. I tried to put a notice in. This is less than 25 words, notarized. Cost me, $15 for it. I walk to court 45, 47 days prior to court. And I say, I need this filed and whatnot. And then she goes, well, I don't deem this as a legal document, and therefore I'm not going to move forward with it. And I say, well, what is your determination or factor findings of law that this is not appropriate? And she says, well, it's not a legal document, and therefore, state of California, I've got the authority to not accept it. And then I kindly say, oh, okay, so you read it then. And she says, well, yeah, I read it. I said, so at this point, you've read whatever that I've said in 25 words or less, and you're deeming it legal or non-legal. So are you giving me legal advice? And she's like, well, no, I'm not giving you legal advice. I'm like, well, if you read it, because that's not your curriculum of work. That's not under Rule 44. You're supposed to take my document and file it. You're not supposed to determine whether it's legal or not. Therefore, you've read it. This notice is not for you to read. This notice actually is not for you. It's for court. And what is court? For all men here on earth. The next thing that I know, I've got 6 bailiffs around my ass shooing me out of court. And my days of violence or my days of, war was 10 years in the military. I'm like, man, I'm never going back there again.
Well, I want you to explain to John Eric Roca how he does it. He gets a freaking thing to go to court. What does he do? He sends them a notice, and he says, what you talked about earlier. It says, for my performance in this constructive trust, my fee is blah, 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 because slavery and involuntary servitude is illegal. And every time he sends them that letter, guess what they send him back? We don't need your services. He can attest to that, and he is in this group. And every so often, he does come on here. He runs with exempt plates all the time. I've got a picture of his plates. It's got his family crest. I've shared a picture of both of them. That's in Texas.
And here's the skinny. I won't say here's a skinny, but I believe that to be true. I believe what you're saying to me is truthful. And what I'm saying is, I have, in my honest opinion, the most scrutinized notice. Every word that don't need to be there, it's gone. I'm going to go ahead and say this truthfully and as concise as I possibly can, as if a 12-year-old read it. I have redone them and redone them and redone them and redone them and spent hours ensuring that it's clear, it's concise, it's reasonable, therefore believable. And I have physically walked down there and I've been escorted by the bailiffs and they're not taking my forms and so on and so forth. And then I'm like, oh, okay, cool. Well, I'll do this. Registered mail. Registered mail is like, well, this is an insurance policy, blah, 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 as well as certified mail. And I get back the little thing that says, yeah, we got it. We accepted it, meaning, we've received it. But then they send me back my shit saying, declined.
Yeah, they declined your contract. When you submit a contract, don't the other party have a right to decline it? Yes.
Not a notice.
Still a contract.
They can decline, or I should say squash or decline a motion. They can decline a declaration. They can decline these legal terms, but they cannot decline a notice. Because honestly, at the end of the day, it has to work both ways. The ticket, citation, debt instrument, it don't matter. It's going to say the word notice to appear. Do I just send that back to them? Like, I'm declining your notice. Which I've done. I'm like within I don't know, like 9 hours.
With what you know and how long you've listened to me talk,
right?
I don't understand why you're sending notices to the court when the court is not the principal.
Because, Pastor the Way, they are not, when I say they, the man or the woman that authored the words of the complaint have never given me what's called due process, or I should say, they have never properly served me.
They
Meaning they
would
give me.
properly served you the day they gave you the ticket.
No, that's not proper service.
Yes, it is.
It's not. No, it's not.
Go study the law of agency. Yes, it is. All they have to do is put it in your hand. The agent gets service of process when it is delivered to them. What is the
A
agent supposed
process.
to do?
No, Pastor, the way I have to disagree with you, because a proper service process has to come from a third party, non-interested party.
And the cop was the non-interested party.
He is the interested party because
No,
he's
he's
going to be
not.
there at court. Are you?
He is there to attest to the fact of all the facts of what he knows and the service of process. Who is the principal for the name?
I.
What is the job of the agent for the principal? The agent is to forward everything to the principal. You're going to sending things to the court, not the principal. That ticket, yes, is a debt instrument. Yes, that ticket created a constructive trust, and it also creates a security, that security of which goes back to the Treasury. Why does it go back to the Treasury? Because everything revolves around that trust, and the Treasury is the one that creates the currency based on the securities and the notes that are created out in this fictitious world. So the principal trustee is the Secretary of the Treasury.
You send it to the Secretary of the Treasury of your state or the Treasury?
According to the SSA, the Social Security Administration, I showed you the list of trustees. The Secretary of the Treasury in D.C., this Janet Yellen right now, is the head trustee. See, you can't argue the public debt. That's under the 14th Amendment. All they're trying to do is get a debt settled. You're not handling your commercial affairs. You know it's commerce. You know it's the debt. How do you discharge the debt? You send it to the trustees. It's their liability, not yours.
Oh, I'm just trying to grab up my thoughts here on this.
Yeah.
Because yes, you're absolutely correct. I don't have anything. How about this, man? If you were to dissect me and put me under a microscope, man, there ain't not one molecule of my body that disagrees with you.
Then why are you not doing it? You're sitting here sending notices to the court. You're doing this to the court. You're banging your head against the wall.
I'm sending. Okay, here's the skinny. I'm sending a notice to the court because I've not been properly served.
Yes, you was.
I was not.
Yes, you was.
Did you
If
accept
you're
it?
the
Up,
yeah,
okay, look under, what's called properly served, or to serve the defendant, or to serve the plaintiff.
you're looking at the
And I'm and
wrong
I'm telling you
service.
I'm telling you this right now. I got off the phone with the clerk of the county. I'm like, I'm sending you copies which I need filed for court. I need also one filed for the judge in whatever capacity, whatever man or woman's acting at that point in that jacket. But I also need the plaintiff and whoever. And she's like, oh, no. If you send us 4 copies, we're just going to send you 3 copies back. One for the court. The other 3 copies will be filed, stamped and whatnot, but we're sending those back to you so you can serve
Look,
the
you
district attorney.
just
Hold on,
you are
like you can hold on, like you can serve the district attorney. You can serve the this person or that person. She's like, we don't serve anybody. I said, well, you're all there in the same fucking building, aren't you? She's like, well, yeah. She says, basically, we will take all 4 copies. We will file all 4 copies, or at least stamp it filed. We're going to keep 1. So you're going to send us 4. You're going to receive 3 back, meaning you need to send a copy to the district attorney. You need to send a copy to the judge, and then you need to send a copy to the public defender officer and whatnot.
yeah, but your
And I said,
problem.
well, hold on. And I said, well, what do you mean by serve? Like I just put it in an envelope, or I just put it in registered mail or certified mail to that office? And she says, no, they need to be, quote unquote, properly served. I go, what does that mean? And she goes, you need to get a third party, non integral portion of life, give that to that man or woman who's going to properly serve the district attorney, who's going to properly serve the public defender, properly serve, whoever. And I said, seriously? Because I have not been properly served. And she says, well, I'm not going to give you legal advice, but you might want to bring that up at court because I've not been properly served. And just the simple fact that somebody writes a ticket and hands it to me is not properly served, because that man is not a non third party interloper who has no interest in shit.
Looking at it from a court battle perspective, you're right. But that's not what I'm looking at. And you're mixing apples and oranges. In one side of your mouth, you say you absolutely understand that the principle for that name is blah, blah, blah. In your actions, you're doing the opposite. Because if you understood the law of agency, you wouldn't be arguing improper service. As the agent for the trust, it's no different than Microsoft and it's no different than serving Microsoft or McDonald's for hot coffee. All
Lost you. You're cutting in and out.
now, can you hear me? Sorry,
Yes.
my phone was ringing. You're mixing apples and oranges. If you were doing a lawsuit, yes, you're right. Improper service. But on one side of your mouth, you're sitting there saying you understand who the principal is. It is their name, their security, their instrument, their trust. But if you understood the law of agency, you don't freaking all these arguments when you sue Microsoft Incorporated or you sue McDonald's for hot coffee. What do? You just give the document to the agent. The agent's duty is to forward it to the principal. That's it. You're sitting there fighting the court claiming blah, blah, blah. They violated your rights. You're just not saying it.
I'm not saying that the court violated my rights.
No, you're saying the cop did, but you're not saying it that way. But your mindset is that way because you're sitting here telling me I am 100% right, but you're wanting to argue with me. If you truly believed that I was right, you'd hush your mouth, send it to the principal, and say, settle your person's problem. That's the thing that drives me crazy. People, now me and JW disagree on certain things when it revolves around the name, but that trust is theirs. They created it, whether it's the birth certificate or not, that can be debatable. But that is their trust, their securities, their stuff, and we want to sit and argue with the court and go blah 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 and violate the 14th Amendment where you says you cannot argue the public debt. Well, how do you settle the debt? You say, here, trustee, would you settle your person's problem?
Has been absent for a little while, but it's usually a 3 to 7 year cycle. And I think we're about done with La Nina. So probably any year now, El Nino should return to our area.
I didn't even have to send it to the freaking principal. I actually just told the clerk of court who the principal was. And they said, we seal in this record. Because they were scared to death I was going to file tax papers with the Treasury and let them know where the security is at. There's one guy, he actually sent a document to the court asking the judge, whose name should I put on this IRS form 8300? The 8300 form is to report to the IRS any monies or securities valued at over $10,000. What they do? They got rid of his case.
Right, but it also says it says cash. Any cash.
Cash is just a term. Is there such a thing? No, it's all book entry credits. Go read the Code of Federal Regulations in Title 31. 3% of the money supply is cash. Do you think they're only reporting cash? No, they're reporting book entry credits.
Pastor, so on a court case, you're supposed to ask for the 8300?
No, you ask them whose name should I put on the 8300?
That's what I got in my notice.
Oh, that's a legitimate question to ask the judge whose name you should put on the 8300.
Yeah, it's all taxes.
Well, you don't ask the judge. The judge is nothing more than a custodial. He's nothing more than a man that is supposed to aid and abet the plaintiff and the defendant of moving forward to resolve things.
Well, that's fine.
Yes.
I just want to know who
do I ask? The judge and the district attorney and the court-appointed attorney, whether if you have one or not, it's irrelevant. The DA and the court-appointed attorney, they're not representing the man or woman in court. They're representing the estate, the trust. Shoot, when I did that 7-year court battle with family court, after I did the GSA bonds and after the case was over, I called the last court-appointed attorney I had. And I said, how'd you like that stuff I did? Oh, I can't talk to you about that because of attorney-client privilege. Wait a minute. Wasn't that your attorney? I said, no. Look at his filings when he got removed from the case. He admitted to the funds and securities of the estate. He's admitting that I was interfering with his fiduciary duty. We go into these courts and we interfere with their fiduciary duty instead of saying, hey, principal, would you take care of this problem for your person?
So I asked once again. So I asked from the prosecutor and my court-appointed lawyer. Correct.
I deal directly with the clerk.
Okay.
The clerk is the one who does all the investing of monies and securities. Found that in the North Carolina statute 7A-112. Now, are you going to find it in your respective state easily? I don't know.
Is that the deputy clerk?
No, that's the court clerk, the one that manages the courthouse.
Okay.
Typically, it's a judge, but not always. That's why I say we have a fiduciary duty, and we're derelict in our duties. The government can't settle the debt because we're not letting them know. We're sitting there arguing with them and saying blah, blah, blah. Oh, you cop, you hurt my feelings. You didn't do something right. It's not your trust.
Would they give us that information?
Will they give you the EIN? If you go to the right people, you'll get the EIN for the court. Go to your accounting and billing office in your county. That's who holds the EINs for the court because that's who does all the reporting.
Oh, okay.
Man, like I said, I'll send you the videotape where everything was put in the notices ×2, and the man acting as a judge literally says, I ain't giving you the EIN number. I ain't giving you this and that. There is no exchange of money. You're not charging us for the time that you're spending. And I order you to, X, Y, and Z here on the 6th of October. Like every single thing that you should never say, this guy just did it anyway. And what I said, what I'm saying is, yes, Pastor, the way I believe everything that you have to say is right and true and correct. I'm not disputing that. What I'm saying is,
I think it was JW that told me.
The experiences that I've had at court and other people at court, they just don't abide by the rule 2 + 2 = 4. They'll say it's a fucking 11 or 39.
Then who are you supposed to ask for the EIN or the W-9? Is it the judge? No. The judge doesn't do the investing. The judge doesn't manage the courthouse.
All of that, what I'm saying is that is in the notice. The notice is not for the judge. The notice is entitled to the judge. It's not titled to the clerk of the county or the county clerk. It's not titled to the bailiff. It's not titled to the stenographer. It's not titled to the gallery. A notice is a notice to court. And what is court? A man brings court, and that notice goes to all mankind. It's pressed on the record, meaning no man can sit here and say, I'm dismissing your notice.
If you do business with Microsoft and you're going to get a contract with Microsoft, the corporate office, and you
Okay.
need their W-9, who do you contact? You contact the office that handles all the bookkeeping and everything.
Well, actually,
That's why you'd say, hey,
no,
Mr.
the W-9 is not a question that I ask. If I work with Aptiv and I work with ADT, I worked with Brinks, and they go, we are sending you the W-9. Fill
Yeah,
out the W-9 and send it back to us.
that's because they asked you for the W-9 so they can identify who they're doing business with. You
Correct.
also needed their W-9 for your records. The point is, you have not talked to the clerk. And guess what? In the tax code, if the clerk does not give you the W-9, all you have to do is do an affidavit with the IRS showing your evidence that they refuse to give it to you, and that will get them investigated.
Are you talking about the W-4 sandwich?
The W-4 sandwich, that's not necessarily what we're talking about. The point is the W-9 is the clerk is the one that manages the courthouse is
Yes.
the one who holds the W-9. Every single court has it. They also have a page code.
Okay, so when you ask for it, they're supposed to give it, correct?
They're supposed to. That doesn't mean they will. But see,
Right,
you got to
right,
be
and I guess
you
my
got
point
to be
is,
smart about how you do it. What I did was I called the administrative office of the courts, and the really nice lady I got in touch with, I said, I'm trying to find the W-9 for blah, blah court. Give me about 20 minutes. I'll call you back. She, true to her word, called me back, and she gave me the EIN. I said, would you mind sending me a copy of the W-9? Yes. What email? And she ended up telling me I got two courts W-9s. I also got, she told me in the last conversation, we don't have that, but here's the phone number to the billing and accounting office in the county. They can give it to you. Okay? See, we're sitting here bitching and fighting with the court instead of handling our commercial affairs. That's what I'm getting at. We're going in there and noticing them when it's the state's property, it's their crap, and then we're getting mad because they do what they do. You're going to the wrong people. I mean, JW, if memory serves me right, we had this discussion over the birth certificate about the law of contracts, and you have 3 days. Do I agree 100%? No, but I think he's onto something. I said, shoot, when you got the ticket, you had 3 days to do what? Take care of it. Send it to the freaking people. It's under the UCC, 3 days, 72 hours. See, everything in this system is contracts. You agree with that, but you're not treating it like that.
Okay, Pastor, I'm going to ask you this. So you asking for the W-9, okay? When you asking them for the 8,300, aren't you asking for the same thing?
No, the 8,300 is what you're going to put the information on. You need the W-9 to be able to use the 8,300. Every state entity has a W-9. My dad has the W-9 for the United States. Actually, no, he got a 1099 from the United States for $56, and it has their EIN on it. So all he's got to do is take and transpose that information to a W-9. You know. And that was a funny story how he got that. They sent him $56 for the interest of the use of the trust's money when he filed taxes. So for the first time in his life, he actually had to file taxes on the $56. Because why? If you receive funds from the United States, that's a taxable event.
Now let's just do devil's advocate and pass it away.
I don't know too many people that I don't know too many people that are advocates for the devil, but okay.
Well, it's just I'm not. I'm just it's an expression.
I
I
know
don't
it
mean
is. I know.
yeah. I don't mean any discourse or any hatred or whatnot. Now, let's just say in the event that the conversation that you have with the clerk of the county or county clerk or what have you, and you say, hey, I've got this debt instrument or I've got this negotiable instrument or whatnot. I need you guys' EIN number in order for me to, and then this woman literally just says, got no idea what you're talking about. And then well, EIN is an employee identification number. I'd imagine that your court, since you've got business hours, written on your front door there, you're a business and every business has an EIN. So what's your EIN? And she's like, yeah, I got no idea what you're even talking about. Or
I've
hold
never
on,
heard him
hold
say
on.
that.
I mean, I guess, no, I'm just throwing this out there. What if they just tell you point blank, I think you're crazy, and they just hang up on you?
Well, then you do your affidavit with the IRS that they refused. That's why it's best to do it in writing. Send it to them in an email. Every single court clerk has an email. Send it to them in an email. They're going to probably write you back because, trust me, I had this happen with a court. Why do you need it? They didn't deny having it. They said, why do you need it? I said, oh, I'm just looking at issuing a bond to the court, and I need to be able to report it properly to the IRS. Oh, okay. Send me their W-9. If you use things that are plausible, that they would know something about, they'll give you what you want. But if you come in there doing all this stuff you're doing and arguing the public debt per se, yeah, you're not going to get what you want. They already know that you're a threat to what they're doing. Just like when I did the GSA bonds on that family court case. I called up the freaking county executive's office and I said, can you help me out? The lady said, oh, I probably can. I said, I need to know who handles risk management because I'm looking at submitting a business contract to your county and I need to send a copy of it to risk management. Oh, yes, no problem. They give me the name and address of their risk management office. They were self-insured. I already had the county executive's office. So all I did was fill out the GSA bonds, send them to the freaking judge privately, send it to risk management, send it to the county executive, and send it to the lieutenant general at the Army Corps of Engineers. And when I did that, things got really weird. The attorney ran for the hills, and that was when they admitted to the accounts and their fiduciary duty, et cetera, et cetera. See, you got to learn how to handle your commercial affair. Stop arguing with them. If you're arguing with them, they're just going to run over you like a freaking steamroller. Because the USFL said it right one time. They're going to use that credit by your choice or by force. and that is your choice. And what does everybody do? They go in there and argue, so they have to do it by force. They are in Chapter 11 bankruptcy. Help them settle their debt. Crap. Let them use the credit. It's their trust to begin with. I mean, shoot, Dawn, I don't know what she wrote, but one of her parking tickets, we presume, got paid by the trust, not by her. But when she called the fourth court on the parking ticket, they actually told her, oh, yeah, well, she said, I need a receipt or I need a order that it's been settled. So I've got it for my records. Well, we can't tell you who paid it and we can't tell you how much. That's fine. We presume they got it settled through the trust. She never had to go to court. All she did was send her a letter and they got access to the trust. They took care of the ticket. It disappeared. She didn't hear another word.
Well, just to be clear, all of the notices that I sent have been to the clerk of the county, care of the courthouse building and stuff like that. I don't address things to the judge or the prosecutor because
Then if
I
they
got
won't give you the W-9, then, and I wouldn't even write big, long notices. I'd just write them a letter and said, I'm requesting your W-9. Get them to say no.
okay.
And if they won't do it, go to the accounting and billing office for your county that handles all the bookkeeping and do what I did. Say, look, I'm looking at issuing a bond to the court and I need to make sure I properly report things to the IRS. Do you have their W-9 handy? They might not. They might say, yeah, hold on a minute. If they don't have it, call the administrative office of the courts in your state. Somebody's going to give it to you. It's all commerce.
Yeah, I understand. It's not personal.
That's right. It's just business, but
Right, and
we're not
right.
treating it like a business.
Well, I am about as I don't know, as cordial and as easygoing. Like I just have a real quick, couple questions, and
Okay.
it just turns into, you know what I mean? Like, you're being charged with X, Y, and Z. Oh, okay. I'll
Define
accept.
you.
Well, exactly. I understand about the 12 presumptions of law, the 10 maxims of law. It's like, oh, okay, cool. Whatever you want, I am willing to accept it. You want to give me, what, 3 charges? Shit, give me 10, 15, 30, however, whatever would make you whole. Charge away. Say whatever you want, do it, whatever. Great. Lovely. And I'll accept it partially if there's a man or a woman on this earth that can verify that statement or that claim or that's all I need.
Yeah, but that right there is automatically arguing the public debt. Instead of letting the principal settle the matter, you're already arguing the public debt. Because when you're asking someone to verify there is a debt, because that's what the claim is, you're arguing, I need the person with the first-hand knowledge to this debt. What are you doing? So in its simplest fashion, you're arguing the debt.
Right, but the definition of argue in Black's Law Dictionary is to make clear, to polish,
I
to shine.
understand that, but what's the definition in the 14th Amendment?
I don't know.
That's right, you don't. All
I
you
don't know.
can say,
Right, but I don't know, but guess what? There ain't no law that requires me to read.
it's not the point. The point is, it states in the 14th Amendment, you cannot argue the public debt. So guess what? If you can't argue it, then settle it by doing it right.
How do you do it right?
Oh gosh, come on. Whose name is on that ticket?
No,
You
but
already know it's
seriously,
the
like
trust.
are you
What
telling
did
me?
I say earlier?
Right,
If
but like
it's the
right, but
name of
hold
the
on,
trust,
hold on now. Are you literally telling me that I've got court here on the 5th of October, like in
it's
a
too
day and a
late
half?
for that.
I've got like 32 hours or 30 hours or whatnot. And they say, are you Stephen Raymond Smith? Are you saying I am supposed to say, I
Take
am
your
not Stephen Raymond
your
Smith?
business records into court as evidence that that the Secretary of State knows this because you have your fictitious name. I'm assuming it's recorded with the Secretary of State. I'm assuming that you actually got a response from them with their documents showing the fictitious business name in the DBA.
Yes. And I've
Then
already
take
in
your
my notice.
business records in and say, hey,
I've already
as
right. But what I'm saying is I put my notice in. Meaning I don't want to talk at court. Meaning argue or this or that. Has the court, according to my records, this shit has been signed, sealed, delivered. You have my documents or whatnot. You've got my response or you've got my notice. Everything that I have to say is in my notice. Were you driving? Everything I have to say is in the notice.
I
And the
refer you
notice
to
is,
my paperwork.
you
Hello,
know,
all. I've just joined. I'm in England. I've just been shared. This group's been shared in my group. May I interject? Would that be okay?
yeah.
yes, sir, go ahead.
Pastor the way is like, for everything you need to do is shut the fuck up of Stephen Smith, for Christ's sakes.
Hey, it's too early in the morning for
It's
that.
awesome.
Thank you. Yes, I'm very happy to meet you all. I run a private educational trust here in the landmass known as England, and we've got a different setup compared to you. We've got the Temple Bar and the barristers and Black's Law, but we've got a merger of state and a church, so we've got a slightly different setup, albeit to you, but yours, Americans, is codified constitution and so forth. But I read some comments there about the KJV 1611. That's an excellent reference point to use, because in England the authorised version of the KJV 1611 is what the Knights Temple, London Law Society have based their law upon. So when you look at the 10 commercial maxims of law, you will find biblical precepts accompanying them, which is a great way to link the jurisdictions of persons. We've gone a long way into research, and I've and chatted with Santos Bonacci, briefly with Jordan Maxwell. I've been doing this 15 years, and we're looking for the remedy for the public trust. You've just mentioned Amendment 14, where it does say in the Constitutional 14th Amendment that all persons are to be attached to the public trust and the debt there, so co-public trustees and beneficiaries. And I listened to what the pastor was saying there, so there's controversies at law, and what you're saying there with referring you to the paperwork so you don't deviate from the subject matter is excellent. We've researched persons, Black's Law, language, etymology, root word references, Anglo, Oxford. We've looked at American English, and I think some key contributing factors for your remedy to articulate so you don't appear as a sovereign citizen, or as they say over here, a free man on the land. We reference the KJV, particular Genesis, God created Adam, breathed the breath of life into Adam, and Adam became a living soul. So I am here today as David, a living soul on the landmass England, and we are no respecter of persons. It's written in the 82nd Psalm of the KJV in particular that Jesus has said, "Have I not told you that ye are all gods?" And we reference, not because we're Christians as such, and I'm not here to preach Christianity, I'm just here to say hello and to let you know that we're working closely with such paradigms as the Christian remedy, the Saviour, the Christ crucified on the cross for his innocence, from Pontius Pilate washing his hands. So Acts and Romans referencing persons, so God being no respecter of persons. There are legal persons, artificial persons, juridical persons. Even, this is an oxymoronic statement, a natural person. Well, there's men and there's living souls, and then there's corporations that are persons and persons that can be corporations. We in our paperwork reference the birth certificate, the Crown copyright person, our certified person, doing business as I heard you mention then. That's great terminology to consider. I am the executive of the estate of the Jeremita estate. That's my family surname over here. You can be the agent in office for the minor. You can be here to clear up the controversies. So charges and the public side, they can't be argued over here as well. We're in what's called an implied trust with the state since mum registers the birth with the General Registry Office. So we have to go back, for us in England in particular, right back to the beginning, where we are born of the waters of our mum. And then 2 to 4 weeks later, we're registered, and the second coming appears, where the citizenship is born. And mum does that for us, doesn't she? And over here for registration. And when we become 18, we go and take that certificate and use that as evidence of identity when we take the father's name in vain. The father's name on the English birth certificate is in all capital letters, and if you look at language and ancient Latin, Pig Latin, Dog Latin, Legalese, American English, Merriam's, Webster's, it's all there for you. But it's very hard to fight this on the day in court. Your paperwork should precede you, and trust and equity, we're finding, is the way forward with the inclusion of the KJV and full disclosure from government officers, not to be considered to be sovereign citizens or free men on the land, pointing out their own rules and regulations, and we move forward in that way. So lastly, the United Nations, I know they're not everyone's favourite, they're particularly not my favourite, I'm not here to sing their praises, but in the United Nations Universal Declaration of Human Rights, Article 6 in particular, if you go and research it, it does point out that all humans are afforded the right of persons to be recognised in front of the law. So the legal system will not recognise the Temple BAR, the American Bar Association, London Templars and Londinium itself. The Crown won't recognise man, flesh and blood, living. We've changed that terminology. And we have to reference that we have a person and we are afforded a person, and that person, Mr., is our agent in commerce, and that's where the controversies surrounding the name appear, and we cannot accept that liability. But taking the birth certificate or presenting that legal identity to the court to be dealt with regarding the matters and claims and the controversies surrounding the name is a great way that we found to do it, because because that's the corporate body, the body corpus, the corpus juris, the corpus of Christ. It goes back into Latin, English, legalese, and then obviously ecclesia. With it's just so multifaceted, and it depends on what level you're at and what you're trying to achieve. But a last will and testament, finally, if you look at a last will and testament and look at what they are and look at probate, wills and probate, when you go into court, you're considered improbate. You might be considered dead and lost at sea, a legal person in an implied public trust. So if you can look at you mentioned the 12 presumptions of the court, they presume certain things, so a way of undoing this implied trust and amending these misconstrued relationships we find ourselves in by the state's unconscionable actions is to try to do private estate administration. And a key area that I'd urge you to consider looking in, and it's as valuable for Americans, Canadians, New Zealand, Australia, the Commonwealth, the occupied foreign territories of the Crown with the Vatican above it, is to undo their presumptions in the form of expressing as a deed, which is a type of a trust, a last will and testament privately, and looking at powers of attorney, assigning powers of attorney, and by doing so, and looking at what public offices, state offices, levels of, I'm not sure of America, but over here we have various ministerial, when I say the church and the state are fused in England. We just saw the Queen's funeral, and you saw the military mixing with the ecclesia and the church therein, and it's the same all around the world, but just portrayed in a different way. So we have to look at how to communicate with these offices and inform them, and by expressing and informing the new relationship. And when we appoint ministers of the UK government in their fiduciary capacity as a trustee, they are compelled to accept those duties, and they cannot disclaim them. And how we do that, other than the propositions of trust law and the maxims of equity, is by the ministerial code, which is overseen by the church, obviously, and international remits, but they cannot by the ministerial code. And we have ministers in the head of the UK Directorate Government, which is a corporation, masquerading as a company. The UK and the government is a corporation, so we have to play them at their own game and hold them to account. First Jesus would quote the accuser's law, and then he would quote God's law. So we find a lot of remedy in tangible historical, publications such as that, and their own legislation, equity and trust, looking at the legalese and the implied meanings and definitions for the purposes of clarity and the avoidance of doubt. We are speaking plain and simple American English or Anglo-English for us, and we set things out as a precedent like this. Our paperwork precedes us. And we never really express private trust to the court, because by doing so, you will collapse the trust. So if you're aware of the Cester KVs of the 1540, 1666, 1707 for us, it goes back to 1302, Pope Boniface, for the first ever proclaimed testamentary trust, from the Vatican City itself and the Crown. So if any of that's been any help to you, I'm very happy, and I'm very happy to have found your group and for you to have given me some time and to have listened to me, this simple fool from England. Thank you, and I yield.
I understood a lot of what you're saying. I just don't 100% agree with all of it.
Yeah, we've got different remits because, as I've said, England is the ones that colonised America, and America's been through its own progression through history. And you've got a different setup with your codified constitution and title code and Congress and Senate. We have the Queen, the King, and Parliament, and things are different. We can't mirror you, and you can't mirror us, but we can use certain aspects.
It's not that. It's not really that I disagree with. It's, you started off talking about Jordan Maxwell. Don't get me wrong, I like Jordan. And I think he was very careful on how he said things. But it's like people have the misnomer that maritime law of the sea, and that it brought the sea onto the land. No, they didn't. Under international law, because under our Constitution, it's called admiralty jurisdiction. There's two sides to admiralty jurisdiction. You've got admiralty law and maritime law. Now, yes, maritime law is law of the sea, but nobody discusses admiralty law. See, admiralty jurisdiction is a subset of the law of nations under the law of commerce. Well, the law of nations is what? International law. And like in America, Article 1, Section 8, Clause 3, Congress has the exclusive right to regulate commerce. So I think that's one of many things where the misunderstanding lies is our governments have certain rights. And that's why everything boils down to business or commerce. It's nothing personal. You know, they're trying to handle commercial affairs. We, the people, don't know how to handle our commercial affairs. See what I'm
Well,
saying?
yeah, we're not people, but I know I'm not having a go there. That's as the old adage goes. Look
Yeah,
up the law merchant. I'm aware of the Phoenicians going back to
yes,
the Canaanites and Phoenicia, and I know where you're coming from there, and that's underpinned by various treaties and
yes.
edicts and so forth. Yeah. I'm not. God, it's too much information for me just as a introduction and a hello to this group as a guest, if you like, as a newbie that's joined. But the law merchant, the codes that are running
The law,
the commercial,
yeah, the law
yeah,
merchant
the
is
Lex
commerce.
Mercatorium, yeah, commercial, maritime, and admiralty. From what I understand, we got merchant traders, merchant bankers. So when we look into the word maritime, mermaid, so it's made of the sea. Mer is the sea, which connects us to Phoenicia before the black nobility was kicked out and moved to Venice. Venice being on the sea, but with regard, and then we go forwards in time, missing lots out. But you're right, there is a rank within the society, and those two separate political standings. You're right again. Yeah, the maritime codes would be the law is the governance of the ships or vessels. You go into ecclesia and church speak, you go into vessels. I am a soul housed within a vessel. In the seas of commerce, there are seas of commerce. You've got the common law of the land, admiralty maritime relating to the sea, and in the air, you have the trust law. Like you may have heard that there are heirs to an estate. So HEIRS is the way you say heirs, isn't it, to estate? But there is AIR. Phonetically, they sound the same, until you see them written down. So the Admiralty law does seem to govern the terms and conditions, aka the statute law of the ships and vessels. Corporations are fictitious vessels or ships that are governed by the law of the sea. Legal persons are the objects and things that are incorporated. You look at the Ecclesia again in the Church Dictionary, incorporeal and corporeal is a corpus and body corpus juris, and they are subjects to the title, the trustee, the debtor society. You've got tacit acquiescence going in there, but yeah, it's all about, it's madness, isn't it? It's insane, Dante's Divine Comedy. But your paperwork preceding you, looking at equity and trust law. In England, I've researched the 12 maxims, 10 commercial maxims of law, and then I've looked and contrasted those and the biblical precepts with the KJV, and then I've looked at the propositions of equity, and one of them is, an equity is equity, whether it be in an English court of equity or an American court of equity.
Yes.
Equity is the same, isn't it? So you can have from me that one of the most valuable maxims that we've seen in equity is this one, where it's quoted, and I paraphrase, where the laws of common law and those of equity collide, those of equity shall prevail. And that then gives you
Yeah,
the upper edge to move the at law levels. So I'm sorry,
yeah,
Pastor, I'm going on, but I'm
yeah.
going to
But
say
no,
thank you and yield.
the point I was getting at though, is you went back to the law of sea. Okay. The point I'm getting at is admiralty law isn't law of the sea. It's still contracts in commerce. It's contracts over the land that are in commerce. Okay. Now, contracts over the sea is maritime law. Okay. Contracts over the
Mhm.
land in commerce is admiralty law. And that's the big missing thing that people are not realizing. See, there are contracts in commerce both on land and sea.
Mm-hmm.
You know,
I
so
agree. Yeah.
so when we understand that, then we fill in the missing piece when it comes to this commerce game. See, people have gone into court arguing maritime law, law of the sea, and the judges just laugh at them. Why? Because the judges know that there are commerce contracts over the land, but the people never overhear. One of the things I preach, quote unquote, religiously is people say that the Constitution is the most important document that we have. But guess what? Nobody studies it. And they make a lot of claims that they truly don't understand, when the very document that's supposed to be this all-important document, they publish a book that tells you exactly the meaning of it, but nobody will read it. And
I hear
now
what you're
I
saying.
will disagree on another point. The differences to a degree between us and y'all are not really that great, because if you go back to the Treaty of Paris, DC and its insular possessions are still owned by the crown.
Yeah, there's 3 crowns though, isn't there? The papal crown, the crown on Elizabeth's
Yes.
head, and for us, the Crown Prosecution Service in London, in London City, that's ensconced itself since 1066 in London town. So London City is a separate jurisdiction to England, and the UK is based there in the square mile. Then we've got the Vatican City, which is the world's smallest country on the Italian continent, separate jurisdiction, and then you've got Washington DC, which is separate to the land known as America, and Washington DC
Yep.
holds. So yeah, we've got to iron all of that out as well. Yeah, it isn't. Yeah, ecclesia running as well. So the papacy and the ecclesia, the canons, just also what we've learned to do in England, rather than we've gone down common law routes and Magna Carta routes and constitutional routes, but unfortunately you can't go into a de facto lower court, a non-crown or high court, and start quoting constitutional defences, because they're not able to hear that. They don't recognise that. They should do, but they are corporate business seeded in London that operate throughout the country. Magistrates, I'll mention, for one, that we're all familiar with. So what we've learned to do is look at the civil procedure rules of the .gov UK and of England, and look at the practice directions. He who makes the claim is duly obligated to provide the material facts of the matter, aka, to summarise, he who makes a claim has to have the burden of proof. That's why you've got your Fifth Amendment, the rights to silence. Your silence cannot be deemed as to be taken as guilt or a sign of guilt. You will let the officers, the state troopers, the claimant who's putting on the charge, prove their case by being silent. You don't want to speak when you don't have to, and give them information and do their job for them. Basically informing on yourself. You've got your Miranda rights that are read to you. Yeah, so you would be better off looking at, if you haven't already, I'm not sure where, Pastor, you seem very astute, and I'm just saying it for the benefit of all. You would be prevalent, it would be, pertinent for you to look at the practice directions of your codified system, where in England we've done so, and we find out that we can have the rights to silence. They're internationally given, and they're given within the remit of the practice directions of the civil procedure rules in England, and let the claimant provide the burden of proof. If you keep quiet, it's not always a good idea to keep quiet, but you see where I'm going there. We conditionally accept all claims and charges. We don't deny them. We don't accept them. We do a third option, which is we will conditionally accept them, and if it's financial, we place the account into serious dispute under the Office of Fair Trading and the Financial Conduct Authority, which is how the clean hands. I can't find any fault with JC, but I'm going to crucify him anyway. An innocent man died, didn't he, in the great story there in the book, and Pontius Pilate washed his hands of him. So there's a thing called the clean hands doctrine for us in England. So for us to keep clean hands when a controversy is raised, we put the burden of liability back on the claimant, no matter what the claim is, the charge, and then we require further proofs of that. We use the relevant public governing authorities, and we reference that, and then we wait for the paperwork to follow. If it doesn't, we send them a notice of fault, an opportunity to cure. After the conditional acceptance, accounting to serious dispute, we're complying with the civil procedure rules of the London Society. We have clean hands. We've accepted there's a controversy, and we're willing to deal with it. If they don't get in touch, notice of fault, opportunity to cure, nudge, nudge, you know, and then if there's nothing after that, or there is something, but it's not of substance, and they say we're free men of the land, sovereign citizens, yada, 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 we send a third notice and a final notice, and we say notice of default. And now, once the claimant is in a position of fault and default, they don't have the status, standing and capacity to bring that claim to court. They are in dishonour. They have unclean hands. So your paperwork then, when you go, like this gentleman's just said, he's got a hearing, a trial, a case tomorrow, yeah, he would then collect, if he'd done the certain processes that I'm privy to in England. I can't say for America because I'm an English man, but then I would file the paperwork, the necessary paperwork. I would take a copy of the birth certificate of my certified person with me, which is the security. The surety for the civil debts is the security, and the securitized instrument there that Mum gave to the General Register's office when I was a baby was like Mum gave the General Register's office a golden bar, you know, and the Register's office for the state keeps that gold bar. Mum didn't give any instructions of what to do with that gold bar. She didn't say that's David's equitable relief for for his future, and you're the custodian and you shall hold it until. So yeah, we've come a long way with playing the game and boxing them into their own areas and holding them to account, and then that some of that's repeated from Franco Collins. What's led me. I said I've been doing this a long time, so I'm happy to impart any information that's Anglo-based and Vatican-based and what would you say there, financially based, because we're corporations trading in bankruptcy and securitizations. The United Kingdom is registered on the Securities Exchange Commission. So
Yeah.
so we've had to do a lot of digging. It's very, very deep, and thank you again.
Well, now, what you said about not bringing the Constitution into court, I mean, if me personally, they've never told me that, as in any of my dealings, because my response would have been, wait a minute, Article 1, Section 10 still applies here, don't it? Which is what? The contract clause. So if the Constitution doesn't apply, then why are we here? I mean, I'm pretty sure England has a contract clause in their constitutions, right?
Yeah, but it's down to the jurisdictions of the court. It may be very well. That's why I said so humbly. I'm not here to comment on America. I can only give you what's happened here in magistrates and crown courts from us having skin in the game. And effectively, we have discharged some charges, traffic officers' claims, and so forth, using what I've given you today. So, a court of the United Kingdom is not a court of England and Wales. A court of the United Kingdom is as Halsbury's laws talk about, as Bouvier talked about for you, as Blackstone's will talk about for you. If you research the Bouvier's and Blackstone's treatises and commentaries on law for your side, we have Halsbury's laws of England over here, and we recognise the jurisprudence and the jurisdictions of the lower de facto, basically Freemasonic crown, de facto horrible places, cult buildings. They're not courts, they're business venues, if anything, and they're not courts of record, and there is no jury there, and it's just if I don't want to swear, but it's bogus, as you would put it then. So then we look at the courts of England and Wales, and we look at the jurisdiction and jurisprudence of Crown and High Courts, the Royal Courts of Justice, and that's where we would, as an appellant, get the correct. We could mention Constitution there, but in a magistrate's court of the United Kingdom, that would fall on deaf ears. It would aggravate and vexate, and it would would end up in a summary judgment being awarded because we didn't present or represent correctly, and so therefore we would end up losing, and we have done because we've tried it. Many have tried it, and we've had to recognise that then we need to go to the Supreme Courts, as you would need to go to the Supreme Courts of Justice, you know, and look at as an appellant appealing and moving it down the line that way. So you're right, yes, but it depends on the jurisdiction and where you are and what type of court, and how you would need to include that in your defence, or how you would expedite the claims dealing with the controversies surrounding the state-owned name. You know, names are for companies and corporations. I am called David. My mum called me David. That is my Christian forename. I'm a man with the name David. I'm commonly known as David.
I understand what you're saying, but I disagree when it comes to contracts. Contract law is a universal law. Every nation understands contract laws. That's why every nation does business with each other.
Yes, and
Okay?
we see those contracts as an agreement. If somebody gives you a contract, yeah, you know, I can tell you know already what a contract is. A meeting of the minds. Two men will agree and two men will sign. If you get given a bit of paper
You don't need a
from somebody,
signature.
no, not always verbal, shake of the hand, a bit of spit, shaking on the hands here in the private, but for commercial contracts that we know as commercial contracts, they are often one-sided, and you're given a bit of paper to sign, like a bank loan. It's a contract, like a telephone mobile contract for your mobile phone, for your utility bills. You know, you signed something that was given to you. You didn't construct it yourself. You are in a constructed agreement. Construct is a terminology of trust law. So what we know as contract law here in England isn't contract law. They're agreements, and they're constructed, and they're given to us by somebody else. We would use what you're saying there. We would use for contract law, because the UK is a registered corporation on a Securities Exchange Commission. Then we would use Uniform Commercial Code, and we citate some of that, you know, as well as executing as the beneficiary of the public trust and appointing those in office using the Ministerial Code trustee, which they've got to do in their fiduciary capacity. So retainment of rights comes down to how we finish the notice and how we present. I autograph, which is again names start. It's if you go into English linguistics, the name starts with a capital letter. It's a noun, and a name just denotes an object or a thing. We are none of us here today objects or things. So when I add authority as the author, I will put an autograph. All of these words are very powerful, and they begin with AU. AU on the periodic table of elements denotes gold. So it's very, you know, we look at it's dark and it's sick in some ways, but it's the facts of the matter. So when we sign off and we present and we communicate with thumbprints and autographs, and sometimes to retain rights if we see it necessary and it's deemed necessary. We've never had uniform commercial codes questioned when we've done so for further retention of rights. So again, yeah, the contracts that the legal system that your law society and your solicitors and attorneys will know as contracts.